Unacademy. Let's crack it.
Mr. Prince, introduce yourself academically.
Sir, my name is Prince Kumar. I belong to Patiala. I have completed my Bachelor's of Law in 2017 from Punjabi University, Patiala, and thereafter my Master's in 2019 from Kurukshetra University.
In which subject have you completed your master?
Sir, I have completed it in corporate law.
Corporate law.
Yes, sir.
Okay. And since which year you have decided that you will go ahead for judiciary only?
Sir, since the very beginning, when I have joined my law course, I had a dream of becoming a judicial officer. And from then only, I have decided that I will go for this.
Okay. Can I presume take it as a year of 2014?
2012, sir.
2012 as well as. Okay. So 10 years ago, you have decided that you were going ahead for the judiciary.
Yes, sir.
Fine. And instead, you have chosen the subject corporate law in your master degree.
Right, sir.
There is anything which a judicial magistrate for which you are going ahead, anything to do with the corporate law for a judicial officer?
Sir, there are some aspects such as the subject of negotiable instrument act, sir. It is to be dealt by judicial magistrate only. It was also part of my subject during LLM. And sir, the basic laws of contracts also help a judicial officer in his dealings with cases, sir.
Your first answer is the Negotiable Instrument Act, in which a company, in which a corporate company can only do that. Why you're thinking so? Negotiable Instrument Act whole is not dealing with the offenses. Only the last chapter is dealing one, right? And there is also the check dishonor matter.
Right, sir.
So the company is the accused there. That's why we are dealing that thing. That chapter is specialized for company only.
No, sir, it is not specialized for company only, but it provides for that if the company is an accused person, then, sir, the company can be made liable under section 138 of
the company can be made liable under section 141, or the director or the manager concerned person will be made liable for there.
Sir, the company as well as the person who is in charge, such as director, manager, can be held liable.
Okay, and what is the exception where the director will not be liable under section 141?
Sir, if the act was not done with their connivance, with their consent, or he has taken all due precautions to prevent that offense from happening, in such case, sir, then the liability of director, etc., can be absorbed.
Are you able to recall there is one more ground where there is no liability of the director under 141?
Sir, if such director is an honorary director designated by the central government or the state government, in such case also.
Okay, fine. There are provision of as to company in CRPC as well as, which are specifically dealing with the corporation. What are those provisions?
Sir, section 305 deals with that when the accused person is a corporation.
Fine. What is difference between CRPC section 305 and 141 NI Act? Conceptually, what difference is there?
Sir, I seek apology, sir. I am unable to recall it, sir.
You are unable to recall it. It's fine. Have you heard about the NCLT?
Sir, it is National Companies Law Tribunal, sir.
Okay. So it is a kind of tribunal. Can I say it is a kind of court of justice?
Sir, it is a tribunal. It is not a court of justice.
Fine. Then who is the presiding or chairman of that NCLT?
Sorry, sir. I don't know, sir.
You are a student of corporate law, na?
Yes, sir.
Under master degree?
Yes, sir. I seek apology, sir.
Okay. Which law governed the companies currently?
Sir, Companies Act 2013.
2013. And earlier, which one act was which was replaced by 2013?
Sir, earlier it was Companies Act 1956, which was replaced by 2013 Act.
Okay. In CPC, there we have a specific order which is dealing with the corporations, firm, etc. Are you aware about that particular order under Schedule 1 CPC?
Sir, I am not very sure, but in my belief, sir, it is Order 29.
Order 29. Okay. Let me know something about that interpleader suit. What was that? क्या होता है वो?
Sir, when the question is about any property, whether movable or immovable, or any debt, or, and sir, two parties are claiming adversely to each other. And sir, the person in whose possession such property or debt is, such person has no interest in the suit. Then sir, he can file an interpleader suit, and both the parties who are claiming interchangeably can be made defendant.
In interpleader suit, the interpleader has one right, which cannot be taken away. What is that right of that interpleader person?
Sir, he has a right to representation. He can file a written statement and his submissions. It is a part of the principles of natural justice, sir, and it cannot be taken.
This thing has been mentioned, or it's a output of your mind?
So it is not mentioned, but I have think that since filing of written statement is a matter of natural justice, so he is allowed.
Okay. In CRPC, when it talks about the trial, there is a specific segment after the court held any accused person guilty. There is a special procedure after which court held the person guilty. What is that special procedure need to be followed after holding any person guilty?
Sir, that is the procedure of hearing on sentence.
Hearing of sentence. Okay. And where it has been mentioned in case of a judicial magistrate trial?
Sir, in the judicial magistrate trial, sir, it is not mentioned, but it is impliedly read into that, sir.
Are you very sure about it that it has not been mentioned, or you're currently not able to recall?
Sir, I am not sir, able to recall at that time, sir.
There is an offense in IPC which was held unconstitutional due to such kind of trial, that is hearing of sentence. What was that section?
So it was section 303 of IPC.
And in which case it was held unconstitutional?
It was held in, sir, Mithu versus State of Punjab.
It's Mithu or Mithu Singh? What was the correct name?
Sir, as far as I am able to recall, it was only Mithu versus State of Punjab.
Mithu versus State of Punjab. Okay. Let me know any 3 sections of IPC which are held unconstitutional, including 303.
Sir, presently I am able to recall only section 303, sir. Sir, there are certain sections which were declared unconstitutional, but sir, currently I am not able to recall these sections.
I am giving you the hint. The section which has been held declared unconstitutional, it can be a ground of divorce.
Yes, sir. That is bigamy. That is, sir, 497 of IPC. And sir, yes, sir. Section 377 was also declared partly unconstitutional.
The offense is offense of bigamy.
No, sir. Offense of adultery, sir, under section 497 of IPC.
Bigamy or adultery, or are you going to switch your answer?
Sir, it is offense of adultery under section 497.
Adultery.
Yes, sir.
And where the offense of bigamy has been mentioned?
It is mentioned in section 494. Sir.
And what the 495 dealing with?
Sir, it is that if bigamy is committed without and the subsequent spouse was not disclosed about the fact of prior marriage, then the punishment is enhanced.
Under 495, there is a concealment, right?
Right, sir.
You told that concealment with the subsequent marriage. So concealment with subsequent marriage, subsequent wife, or concealment with the prior wife?
Sir, concealment of former marriage with subsequent wife.
Former marriage with subsequent wife. Sure about that, or it had been, you want to change it, vice versa?
I am quite sure, sir.
You are quite sure about it. Section 377 has been held unconstitutional.
Sir, Section 377 has been declared partly unconstitutional.
And what the balance part which is constitutional currently in the IPC?
Sir, the constitutional part is that if the unnatural sexual intercourse is with the consent of the parties, then that is still valid.
With the consent of the party or
Both
with the
parties,
consent of adult?
if both are adult and both are consenting
Hmm.
parties, then the sexual intercourse is valid.
Okay, fine. So both parties are adult. I'm giving a situation. Both parties are adult. Both parties have consented, and at a public garden they are want to do a sexual intercourse.
In a sir,
They will be permitted.
sir, kindly repeat the question, sir. I am not able to hear.
Both parties are adult.
Right,
Both
sir.
parties have consented to each other for sexual intercourse, and they have chosen a place at public garden for doing a sexual intercourse.
Right, sir.
So it will be an offense under 377 or not?
Sir, it is an offense under Section 377 because it should be at private place only.
Okay. So you want to say that thing which can take place at private place, if it is take place at public place, it will amount to 377 because rest of the ingredients are same.
Sir, I cannot make that generalized statement, but sir, if these three ingredients are fulfilled, then punishment of Section 377 will not apply, sir. The first one is that the both parties are adult, both parties are consenting parties, and the act done in secretly, sir. Then Section 377 will not apply. Rest it will apply.
The secretly word has been mentioned under section 377.
Sir, it is not mentioned.
Then how can you say that it is ingredient of 377?
Sir, at public places such, in my humble opinion, sir, these activities are not allowed and they are punishable.
It's your opinion or it's a legal provision?
Sir, I am not sure, sir.
You are not sure. Okay. There are two terminology. One is affray and the another one is riot.
Right, sir.
What's basic difference between these two offenses?
Sir, in affray, there can be two or more than two persons, sir. But in riots, it is essential that it should constitute unlawful assembly. So there must be five or more than 5 persons.
Apart from being unlawful assembly, there is an ingredient for riot. What is that?
Sir, that it must use violence.
Violence or force, or alternatively both can be.
Or either violence or force.
Violence or force.
Yes.
Force or criminal force.
Sir, only force has been used.
Force has been mentioned. The word force has been explained in IPC. Where it has been?
Sir, it is explained in section 349 of IPC.
And criminal force has been defined at
350 of IPC.
350. Okay, fine. Suppose the emergency has been imposed under Article 356. Okay. And a public servant, while discharging his official duty, has committed any offense. And a particular court of judicial magistrate want to take cognizance of it.
Right.
Now,
Sir.
what kind of conditions requisite for such cognizance?
Sir, I seek apology, sir. I am not aware of.
You are not aware of. The word public servant has been defined anywhere?
Sir, in section 21 of IPC, public servant.
21. Apart from it, CPC also deal about public servant or public officer?
Sir, it deals with public officer.
And what the difference between public servant 21 IPC and public officer section 2 CPC?
Sir, public servant may be appointed by the government or may not be appointed by the government. And public officer must be appointed by the government.
So I can say that section 21 IPC include section 214 CPC.
Yes, sir.
Hmm?
Yes, sir. I think.
Public servant and servant of government, both are same thing.
No, sir. Both are not same thing. Sir.
Both are not same thing.
Not same
What's the
thing.
difference?
Sir, appointment is the difference, sir. That public servant is may be appointed by the government, may not be appointed by the government, and government servant is mandatorily to be appointed by the government.
This clause has been given under section 21 that it cannot be appointed by government or non-government. This clause has been mentioned.
So it is there in explanation to this section that whether it is appointed by the government or not.
Section 21 IPC, whether it has given any explanation or not. Any explanation is there attached to the section 21?
Sir, yes, sir, it is there, sir.
How many explanations are there?
Sir, sorry, sir, I do not know the exact number.
How many clauses are there under section 21 IPC?
Sorry, sir.
Categories of public servant.
Sir, I am not aware.
Okay. Under section 191A, if any offense which has been mentioned there committed, then we can adopt the procedure mentioned under chapter 26. Is this correct statement? Offense mentioned under 195(1)(a), then we can go ahead for the procedure under chapter 26 CRPC. Is it correct statement?
Yes, sir, it is correct statement.
It is correct one.
Yes, sir.
What is chapter 26 CRPC?
Sir, it deals with the section 340, that procedure to be adopted when a act is committed by public servant.
Okay. Under chapter 26, that is 340 to 352, how many sections are there which are dealing a separate procedure? There is only one procedure in chapter 26,
So
there are different procedure.
So there are different procedures for different offenses, and sir, various sections are dealing for it, such as section 340, 345, 346, sir. But I am not.
Whole chapter 26 cannot be applied to 195(1)(a).
Sir, kindly repeat the question, sir.
Okay. Offense under 195(1)(a) CRPC can be dealt with under chapter 26. Whether this statement is correct or incorrect?
It is correct, sir.
It is correct one.
Yes, sir.
On one point you are saying it is correct. On another previous point you mentioned that there are various procedure under chapter 26. Then can I say that all different procedure will be applied to that according to you if it is correct one?
Sir, only the procedure which is specified under section 340 CRPC, that is to be applicable in case of section 195.
Only 340. 341 can't be.
Sir, as far as I am able to recall, sir, it is 340 only.
340 only.
Yes, sir.
Okay. What procedure need to be followed for 340 has been mentioned in a separate section. And what is that separate section for 340?
Sorry, sir, I am not aware of it, sir.
Are you aware about the 195(1)(a) and 195(1)(b)?
Yes, sir. Sir, 195 clause 1 subclause A deals with the cases which are committed against the public servants, sir, such as section 172 to 188 of IPC. And 195 1 clause B deals with the cases which are committed before the courts, such as forgery, fabricating false evidence.
So at the last moment, I'm again repeating my statement, and you need to diagnose its correctness. Offense under 195(1)(a) can be dealt with under chapter 26. You modified it 340, 341. So offense under 195(1)(a) can be dealt with under 340. Is it correct one or not?
Sir, I would like to change my statement. It is not correct, sir, because offenses under.
Would like to change your statement?
Yes, sir. Yes.
Okay. So which is the best part of yours in civil procedure code, which you think that you can give a 5 minutes debate on that topic?
Sir, any part of civil procedure code, sir? Sir, it is, sir, amendment of pleadings.
Amendments of pleading. Okay, fine. I'm giving a practical situation and you need to answer it. Right?
Right.
I'm the plaintiff and I lose my case in the trial court. And now I
Right.
want to file an appeal. And
Right,
for
sir.
that purpose, I have filed the memorandum of appeal in the court of appeal. Okay.
Right, sir.
After filing that court memorandum of appeal, I found that there was a clerical mistake in that memorandum. And I want to make amendment in that.
Right, sir.
Now, which provision can be applied here?
Sir, since it is a case of appeal, so Order 41 will be applicable, and in that memorandum of appeal can be amended with the
Which
permission of.
rule specifically? Can you let me know?
Sir, I cannot recall the rule, but it is definitely Order 41.
And suppose in the trial, I want to amend it. Don't you think that Order 16, Rule 17 will be applicable?
Sir, Order 6, Rule 17 will not be applicable because the matter has went to appeal, and it is only applicable on before the trial court.
Why Order 6, Rule 17 cannot be applicable in case of memorandum of appeal? Why?
Because, sir, it is written that the amendment of pleadings must be before the commencement of trial. So, though it is available after trial also with the filing of post, but Order 41 specifically provides for the amendment of memorandum of appeal. So that's why Order 6 Rule 17 is not applicable in case of appeal.
Okay, you can switch off your camera, and after a few seconds, I will get back for your feedback. Thank you.
Sure.
Hello, Mr. Brains. So, how was your interview according to you?
Sir, there are certain infirmities which could have been dealt with, sir.
And out of 10, what weightage you will give to yourself?
Sir, 4 to 5, sir.
4 to 5.
Right, sir.
In your case, I will like to say it should be 6 to 7. I appreciate the whole interview. In fact, at various point of time, you are very good on that command. The concept which you are aware are very well, except few. Except few kaise? Dekho. I would suggest we should not make any conceptual error in the interview. If you are not aware about any particular section, any particular rule, it's okay. Suppose you are not aware about that particular rule of Order 41 in case of amendment in the memorandum of appeal. It's okay. But when you said the logic behind why Order 6 Rule 17 will not be applicable, you have mentioned that it is before the commencement of trial, after the commencement of trial. No. Order 6 Rule 1. Pleading means plaint or written statement. Order 6 Rule 1 do not include within itself the memorandum of appeal. And that's the logic. We cannot include the memorandum of appeal within the concept of pleading. Since it is not pleading, hence we cannot cover it under Order 6 Rule 17. That's it is the logic of this. Okay. And I'm expecting that thing from you. First thing. Further, it was, I would say, it is a kind of grave error when you missed out the concept of any offense against a public place. Right. Suppose कि अगर 2 person ने अपनी consent से public garden के अंदर sexual intercourse कर दिया, तो उनको आप 377 का offense नहीं कह सकते. But they have committed the offense of obscene act. Obscene act you are aware about?
Yes, sir.
Obscene act, chapter 14, section 292, 293, 294, specifically the section 294, obscene acts and songs, etc. So obscene act is a thing is obscene when it is performed at public place. If a person is nude, within his room, within his house, then it's not obscene. But if he's nude at public place, then it is obscene.
Right.
Okay. In that case, you have to apply. Your answer must be that, sir, in such a case, we will not apply the 377, but we will certainly apply the section 294 of IPC. That must be your answer, because it's showing your conceptual clarity. I have specifically asked you whether secretly word has been mentioned or not. You deny it, say, oh, no, it has not been mentioned. But at the same time, you find yourself unable to link that concept with the 294. Actually, this is the game of linking. When we apply 294 with 377, both concepts will be connect simultaneously. And it's essential. Further, I have 3 or more harsh points. Should I continue? Fine.
Sure.
Third point is you have used the word right to representation orally under interpreter suits. No, I would suggest, listen one thing. In case when the specific provision has been made, interpreter suit a special suit, okay? And in a special suit, there are special provision as well as. Okay,
Right, sir.
natural justice is a far behind principle. It's a far behind principle. You said right to representation. He is representing himself. That's why the court has instituted the suit. Now further, what kind of representation he can demand?
Right, sir.
Think about it.
Right, sir.
Got it? The court had instituted his suit. It means what? Court has already admitted his representation towards itself.
Right, sir.
Now further representation will what? He will become the Bahubali. छोटे से बड़ा हो जाएगा, ऐसा तो है नहीं. Actually, my answer is the right to claim the expenditure which has he incurred on that property.
Right, sir.
जो expenditure उसने incurred किया, he can claim ना. He can say that I have maintained this property for so and so period. Now I want to get the claim the expenditure. That's the reason. Simple. Okay. Further, hearing of sentence in judicial magistrate case as well as section 248 subsection 2, the judgment section specifically mentioned that hearing of sentence should be there. Okay.
Right.
And under section 235 subsection 2, the session court has mentioned that the hearing of sentence must be there.
Right, sir.
Is that clear? Further,
Yes.
bigamy and adultery. I'm not expecting that you will give a wrong answer as to bigamy for the word adultery.
Yes, sir.
Bigamy is totally different. It's a slip of tongue. Then you must hold your tongue very carefully.
Yes.
Okay. It's a basic thing. Joseph signed was the case in which it has been held unconstitutional. And when I asked you for 377, then I'm expecting that you will also mention the Navtej Singh Johar case.
Yes, sir.
Anna? But I was missing. that case name, and you have not mentioned it. And it's Mittu Singh. It's not Mittu only.
If it was specifically asked, then I should ask, say for it. Otherwise, I should abstain
So,
from.
listen, if we are aware about the case title, legal provision, then we should go ahead. Why not?
Yes.
Because we are going to impress that board, that we have the knowledge, and you are giving the relevant answer. I specifically asked unconstitutionality of 377. In that case, you can mention that it was partially declared unconstitutional by the case of Navtej Singh Johar versus Union of India in the 2018. That's all. Otherwise, it's okay. Fine, but you need to work on these things here, right?
Sure. Sure,
Okay.
sir.
Okay. Thank you so much. Anything else you want to ask?
Thank you, sir.
I hope you enjoy your interview.
Yes. Yes.